This is Colin O'Keefe for LXBN TV. What is the best way to deal with politics in the workplace? The instant reaction by many, of course, is to try to avoid the subject completely, but that doesn't always happen. Joining me now to discuss the issue is Tiffani McDonough. She is an attorney in Philadelphia with Obermayer Rebmann Maxwell Hippel and author on the firm's blog, HR Legalist. Tiffani, first, let's start, of course, with the legal side to this, the legal side to politics in the workplace. Are political beliefs something that employers could potentially discriminate against?
Well, Colin, it's interesting. It depends really on if you're talking about private sector or public sector employment. So we'll start with the private sector. In the private sector, there's actually no federal law that prohibits political affiliation discrimination. However, what you have are certain state statutes that are going to afford those protections to employees. So, for example, in California, Louisiana, District of Columbia, and New York, there are actually statutes that explicitly outlaw political affiliation discrimination. You also have statutes that outlaw political coercion by an employer. So what I mean by that is, for example, in Arizona, there is a statute that prohibits employers from placing employee paychecks in any type of envelope with a political motto on it, or any type of political insignia. In Washington, employers are actually prohibited from taking any type of contribution, an employer-mandated contribution, from an employee's paycheck. So in the private sector, you have to look at what the states are, what they're doing, and what their statutes are, the protections they're affording. Now, in the public sector, it's completely different. The general rule is that you cannot discriminate against an employee based on their political affiliation, with an exception if that employee is in a confidential or policy-making position where they actually have to be a particular political affiliation. It's legitimately relevant to the job. So generally, with a political affiliation discrimination claim in the public sector, an employee is going to have to show that they are in fact an employee of a public agency, that they have maintained a political affiliation, and that political affiliation was a substantial or motivating factor with regard to their subsequent adverse employment action. The other risk that you run in public sector employment is this idea of First Amendment violations. So, for example, employees in the public sector can bring claims for First Amendment retaliation if they feel as though they've been retaliated against based on their political activities or affiliation. In order to bring that type of claim, they have to show that they've engaged in constitutionally protected speech, and that by virtue of engaging that constitutionally protected speech, their employer subsequently retaliated against them. One really interesting point to keep in mind is constitutionally protected speech can actually include things like social media activity. There was recently a case in the Fourth Circuit, just about 2 months ago in this year, where the court held that liking a candidate's Facebook page, or liking the campaign page, should I say, on Facebook, was actually protected speech. So I think employers should really be aware that what traditionally they may have thought was constitutionally protected speech has been expanded to include social media.
Absolutely. I remember that case. It was a very big one within the confines of employment law. And second, what's the best approach looking more at a broad level when it comes to employees and employers and dealing with politics in the workplace? I assume generally, again, that you want to avoid the issue, but how do you go about doing that?
Oh, Colin, that's a really great question because, generally you can't prohibit employees from talking about politics in the workplace. And realistically, as you said, especially around election time, they are going to be talking about it. And as we all know, politics can definitely, turn into a heated discussion. I think what particularly private employers should do is, first of all, you want to be aware of any of the state statutes of the states you're operating in that are going to protect the employees and afford them that protection of political affiliation discrimination. So if you're operating in a state such as New York that has that type of statute, you want to make sure that you're incorporating that into your anti-discrimination policies. You want to make sure that your managers and supervisors are being trained on those policies and make sure that your employees are aware of them. You also want to make sure that you have a reporting procedure in place. So if an employee feels as though that a political conversation has escalated to a point where they think that they're being adversely affected in their employment, they can actually report that internally and you can be investigated and hopefully avoid litigation.
Yeah, absolutely. You, of course, always want to avoid litigation at all costs. Once again, that was Tiffani McDonough of Obermayer Rebmann Maxwell and Hippel. For more of her insight on this issue and other issues in the employment law space, be sure to visit hrlegalist.com, and you know where to go. For more of these video interviews from lawyers like Tiffani, be sure to visit us at LXBN.com, where you can also find curated commentary from our network of more than 8,000 members. Thank you for joining me today, Tiffani.
Oh, great. Thank you.